Hey, good morning, everybody. Welcome back to Law and Legitimacy. No, it's not Monday. We weren't here yesterday, and the world continued to survive. Although there are those who relate the mass shooting in Nashville to our absence on the air yesterday, and I think that mistakes correlation with causation. More to say about that in a moment. Hey, today, Luttrell, it is showtime, and this is the Apollo, and here we are. Thanks for listening. Thanks for tuning in. Lots to talk about today. I think we stumble into day 58 of United States of America versus Joe Biggs et al.
And Norm, keep talking. I need to edit something on our Rumble stream. I apologize to our viewers. I think I may have neglected to update the stream configuration. So keep going. I'll see if I can do it from here. Or if we want to stop real quick and let me go into the broadcast and change it, that might be beneficial.
I don't know what happened. We broke up for a minute, so I was in Deep Space Nine.
Yeah, 1 second. Let me here. Keep talking. I'm going to see if I can go into to StreamYard and figure that out. 1 second.
Well, so we're having some sort of technological difficulty. I'm actually all alone here without Mike. Let me see if I can figure out how to do that. Day 58, you know, the Proud Boys trial. We're in the defense case. It's likely to linger into next week. I think we'll be giving closing arguments either late next week or early the Easter week. Hey, shout out to Saifullah Khan there. Hey, Saifullah, good to see you. Saifullah is a former client and current client. Look him up in Time Magazine, and you'll see about the case that we beat and earned national scorn over. But in any case, in the Proud Boys case, you may have seen a story about confidential informants and spying on the defense team. It's just not true. Here's what happened. We were getting ready to put up a witness in the case, and the government disclosed that this person had been a registered confidential human source at some point during the case's history. We all compared our notes and realized that this is a person who'd been in touch with my client, been in touch with several family members, and we thought, what in the world is going on? So we filed an emergency motion to get a hearing, hoping that this might be the end of the case, that we could prove the government was up to no good. And upon inquiry, we learned the following, that the person had been a confidential human source and had provided the FBI with information, but not with information about the Proud Boys. And thus, she was not a federal agent embedded in the defense camp. She was not interfering with my right to represent my client free of government interference. In other words, there was no Sixth Amendment violation. To get a Sixth Amendment violation of that magnitude, you need the following. You need to show that the government had that the person was represented, that a defendant was represented in ongoing litigation, had a lawyer, and that the government created an informant, in other words, found a person to serve as an informant, sent the informant into the defense camp, and then that informant relayed information back to the government, which it used. In this case, it was not even close. From afar, it looked as though it was a devastating blow for us that we'd be able to strike against the government. But on inspection, what we learned is that while the person knew some of the Proud Boys, she was not an informant sent into the Proud Boy camp by the government and did not report back to the government information from the Proud Boys. So much drama attended this. There was so much press and so much hostile press that continues to be drama generated by it that I speak out this morning. I don't want to mention her name. You can find it easily enough if you look it up online, but we are under a protective order. But we decided yesterday not to call her as a witness. She was going to be a bit witness in the case. It offered just a little bit of information, but all of the publicity around her was so devastating to her. I met with her Saturday evening, listened to some of the messages on her phone. People were conveying threats and hopes for death and painful injury. She's been maligned online and patently false things have been said about her. You know, I'm calling on Julie Kelly. Julie, if you're listening, reassess your take on this woman. You're hurting her badly by making representations about her that, frankly, I don't regard to be true. I can understand why people would make the assumptions they made based on a little bit of information they have. But as somebody who's boots on the ground in this case, who's interviewed the woman, who's talked to the government, who's inspected the documents at issue, there's no there, folks. I wish there were. I wish I could turn this to the advantage of the Proud Boys. I do think that the FBI's use of confidential human sources in surveilling domestic groups is a troubling issue, and this case provides a partial window into it. But be careful before you leap out that window, folks, because it's a long fall from the view to the truth. And when you get to the bottom and you're picking pavement out of your teeth, don't say Uncle Norm didn't warn you.
Yeah, it seems almost impossible, Norm, for this to have not occurred at some point, because it appears to me, observing online and in conversations privately, people want their pound of flesh for what some sort of perceived wrong in connection with January 6th and the widespread prosecution of seemingly anyone who was even tangentially involved or there on the day that the quote unquote, as it's been branded, the insurrection occurred. But as we have said time and time again on this stream, in other contexts, it is extremely important to treat this with the due respect it is owed. This is these are 5 individuals who are part of the same First Amendment protected group, the Proud Boys, but the Proud Boys are not on trial, nor are the prosecutors in this case litigating the widespread issue that people think is being litigated here, apparently, right? So any ripple in the water procedurally, substantively, with the evidence is automatically serves as some sort of confirmation bias that the larger issue, that this was a government setup, that this was, any of these like untoward items that people have sort of ascribed it already, are true. And then to the extent there's no follow through, or there's no head on a spike to show for that, people get really frustrated. So I think that's been, in my experience, sort of observing this, talking to you, Norm, it's been one of the insights I've gleaned, is how difficult it is to manage something that is as well publicized and followed. But when it is, macroscopic, meaning that the Joe Biggs, United States versus Biggs et al., that is a subset of the larger January 6th indictments and prosecutions, right? And to the extent the facts at bar for these defendants, and in particular for Joe Biggs, do not overlap with some of these more exogenous issues, it creates, I think, a situation that is ripe for missed expectations and malignment.
Well, I mean, the thing that's been amazing to me about this case, and coming off of it after coming off the Alex Jones case, is, once a case seems to achieve a certain critical mass, a certain wow factor in the public's mind, people are going to watch the case, and they're watching, and that's a first tell that something's going to be wrong. You got a person you're on trial, and somebody says, I want to be a witness in your case, and your first thought should be, who wants to be a witness in a federal case? Why would anybody want to submit themselves to that? But people are drawn to these cases because of the energy they generate. And I'm not sure what the source of that energy is, but people, when they're drawn to the case, they need to check what their expectations are, because this notion of confirmation bias, of seeing what you want to see in the data, is very real. And it's tragic in this case, because as to this confidential human source, there is a whole public narrative on the right being told about her that just isn't true. That she somehow betrayed people, that she somehow hurt the Proud Boys and whatnot. She did no such thing, and the evidence doesn't support it. The narrative drive, the need to have that happen, the desire for that to be true, that's all real. But facts, as you learn in a courtroom, as every litigator knows, are difficult to prove. And in the 58 days that we have been banging heads in the Proud Boys case, there are going to be some disputes about what people had in mind on January 6th. But otherwise, there's not a lot in dispute. We've beaten this horse half to death. The question is, who's going to walk it? Who's going to walk it to a satisfactory verdict? But let's move. Yeah, let's move on. Hey, so beep, 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 news flash from Connecticut. Even though I haven't been in Connecticut more than a week since early December, there is a hot story in Connecticut, and that's my home state, and I know most of the people involved. Connecticut was the first state in the United States to have a public defender's office. That is a set of lawyers appointed to represent the indigent in serious and sometimes not so serious criminal cases. The public defenders in Connecticut are managed by a commission that has 5 commissioners, and there's a chief public defender, and then there are regional offices throughout the state. The Connecticut public defender system is imploding right now. And as near as I can tell,
that's not an overstatement either.
Yeah, no.
Quite literally, they're at gridlock because, as I put here at the bottom, 4 of the 5 commissioners that I guess on the oversight commission for Connecticut's public defender's office have resigned as of March 23rd, so last week.
In a mass resignation. And so Ed Mahoney of the Hartford Courant has been doing some pretty good reporting on this. And here's what seems to be the case. We have a new chief public defender. Her name is, and I'm having to look on my device, TaShun Bowden-Lewis.
Mm-hmm.
And so she is the person who reports to the commission and runs the agency. There have been some disputes about personnel decisions. TaShun, apparently is who happens to be a woman of color, wants to promote Black public defenders to lead certain regions.
Just a bit. So yes, she happens to be a person of color. However, she was sworn in July of 2022, because I think Connecticut had whoever was in her position prior thereto, did she not get, I guess, nominated for a seat as a federal district court judge? Is that right, for the Second Circuit, Norm?
I don't think that's true. No, there was a federal defender who went to the Second Circuit, Sarah Murphy. No, so I think you're conflating the federal system with the state system. But in this case, TaShun's got the job, and a series of decisions need to be made. Who's going to fill this job? Who's going to fill that job? And the commission was vetoing several of apparently TaShun's recommendations. And TaShun had words to say about it, as did a committee of public defenders who are in favor of diversity within the agency.
Yeah, so that was my point. My point was just to bring up, and again, I'll let you finish here, but I was only to say that you use the phrase happens to be Black. However, NPR and anyone that was promoting or talking about her, her taking this position, used that as the bright line topic heading. It was Connecticut's first Black chief public defender. All right.
Well, yeah, I'm trying to be neutral about it. I mean, because, somebody's got to fill the job. And as long as we're filling jobs that humans can do with humans, they're going to have characteristics. They're going to have a gender, male, woman, or none of the above. And they're going to have a race, white, Black, or none of the above. And so TaShun gets the job because Connecticut is suddenly enthralled with diversity, equity and inclusion. And so she wants to remake the agency in the name of racial equity. And in the town of Derby, and this is where it pays to be listening to Law and Legitimacy and somebody who knows the state, there was a vacancy for the head of the Derby Public Defender's Office. Now, Derby is a largely white working class town in the so-called Brass Valley, the Naugatuck Valley, the home of the brass industry in the 19th century. It's been struggling. It's down at its heels. Derby is a low-level courthouse. In other words, the Connecticut public defender system, the Connecticut court system has high courts and low courts, so-called Part A courts and Part B courts. All criminal cases start in low court, Part B, and if you're in enough trouble, it gets transferred to Part A, to a high court. So the high court for Derby is in New Haven. Misdemeanors, domestic assault and whatnot, the low-level crimes get resolved in Derby. So TaShun's got a candidate who happens to be a Black person. The commission says there's a better qualified person. So they appoint the better qualified person who happens not to be Black. Apparently this happened enough to create rifts within the commission. And the result is TaShun is pissed and commissioners are frustrated. So 4 or 5 of them quit. 4 out of 5 of them quit last week. I know 3 of them. Kevin Russo, a former judge, a current judge, former prosecutor, current judge, Laura Baldini, a judge, and Allison Nearing, a criminal defense lawyer out of New Haven. They all happen to be white. The fourth person, who I don't know, happens to be white. The one commissioner,
Amy C. Goldberg, I think. She's
Yeah.
a licensed social worker from West Hartford, and she's been on the commission since her appointment in 2004. So not insignificant resignation. That's 19 years in service.
And the only one who remains is a former state legislator who happens to be black. Now, you read this story, and it is a parable for our times, because the commission says, look, we like your nominee, TaShun, but we think there's a better nominee. And TaShun apparently responded by saying, if you don't hire the black person, it's because you're a racist. And I think that was just too much for these commissioners to take. And, we get to the point now where racial entitlement has led a young black woman to say, if you don't give me what I want, therefore you are a racist. And I think these 4 commissioners said, this is BS. Why do I need this? So race has been transformed into a Molotov cocktail, and it's been thrown into the management of this agency in a way that imperils its continuing ability to function. And so suddenly all eyes on Connecticut, all eyes on the Public Defenders Commission. Can we have a legitimately race neutral but inclusive public defenders agency? And the answer is no. Not if you put a black person at the top of it, and the first time they don't get their way, they start whining about racism. The fact that, these commissioners who resigned, at least the 3 I know, they're not racists. Nearing's a longtime criminal defense lawyer involved in very complex and difficult cases, has worked at highly respected firms. Russo is a former prosecutor who cut his teeth for 25 years as a prosecutor and judge, and who has an insight into the criminal justice system. Baldini was a former chief administrative judge in the criminal courts in Hartford, one of the state's larger cities, knows a little bit about how to evaluate a file and how to evaluate a case. And then we've got a social worker with 19 years experience. Why we have a social worker on, I don't know, but we do. These people, I think they just threw in the towel, and they said, we've had enough. Now, a gaggle of TaShun Brown's supporters have formed an email, and they call it the Malcolm Little email. That was the name of Malcolm X before he became Malcolm X. And they're writing pseudonymously about racial tensions within the division because they fear repercussions if they don't. What is going on here, folks? I understand the need for racial justice. I believe that the arc of history is long. I believe that there is a stain called slavery in American history. I also do not believe that the path forward is some sort of racial tit for tat, wherein we somehow deify the current occupant of a job because they're black, and that person therefore gets the right to say, if you don't give me what I want, you're a racist. That is illegitimate. I think TaShun Brown's got to go. And it would have been far better for the Criminal Justice Division and the Division of Public Defenders in Connecticut for her to go rather than to lose 4 of 5 commissioners, because now we're going to have to restaff the commission with people who don't have institutional history or memory. And they're going to have to come in and they're going to have to lead one of the most important participants in the criminal justice system, the public defender system.
Yeah, and not to mention that this is going to be a position each of these new candidates arrive to that is embattled with litigation. As I've put on the screen there, the chief public defender has retained her own counsel. There's been an announcement of an inquiry into the office itself. Governor Ned Lamont is, assuring people that he'll help, with, I guess, continuity. But right now, the purse strings are tied. Decision-making on hiring and other resources are tied up. And ultimately, the public defender's office is charged with helping indigent defendants with a legal defense. And so if you put this in proper perspective, Norm, this if there's any criticism to be had for these 4 or 5 commissioners, it would be that the interest that they ultimately serve, it goes to the detriment of those who need the resources.
No, and let's be real about this. Connecticut, I mean, you're going to say, well, public defenders, aren't they representing mostly black clients? No. In Connecticut, 14% of the state's population is African American. Derby is it's not quite suburban, but an exurban city. The majority of people being served by public defenders in Connecticut and Derby are white. So it's not as though we needed some black symbol to go into a depressed urban area and say to a largely black population, here I come to save the day. I'm going to null your crimes in the name of racial equity. This is just all garbage, and it's deeply embarrassing.
And look at this. So I mean,
it's deeply embarrassing, as Justin Carter says.
You talked about because they call it an anonymous email, but I think it's properly pseudonymous, as you've already pointed out. But it was provided to the Hartford Courant, which we're using as the primary source on this, by a senior public defender. So they're remaining anonymous. But that email was distributed to select recipients, apparently. And it's more than likely from the executive team of what's called the division's Racial Justice and Cultural Competency Committee.
Oh, please. I mean, if ever there were a reason
that's a thing that exists, is what I'm saying.
Well, and that's another reason to hire private counsel in a criminal case in Connecticut. You can reach my office at 203-393-3017. I mean, when are we going to stop cluttering up the world with this garbage? I was reading stories over the weekend about tensions around the world, and in Asia, Japan is thinking about rearming in ways that it hasn't since the Second World War. Many Asian countries are concerned about a resurgent China and a reawakening of tensions in the region that we haven't had for some years. Obviously, we've got the situation in Russia and the Ukraine and tensions there. And what is America's role on the world stage going to be going forward? And my sense is, if we were caught in an international conflict, we'd be embarrassed because we don't even have a national sense of self. I mean, we're so busy about diversity, equity, and inclusion. What are we going to send a bunch of transgender people into the front lines to transgenders to the rescue? We're here for Taiwan. No, they'd probably be bitching and moaning that there wasn't enough whatever transgender people need to feel like they could be successful warriors. Or the Diversity, Equity, and Inclusion Committee of the Defense Department would decide, well, wait, we can't send this battalion into the front lines because there are too many, Latinos, or not enough white men. Or maybe if the mortality rate's going to be that high, it should be stocked with white men in the name of equity, diversity, inclusion. All this stuff is just chatter and noise. And I think the Connecticut public defenders system is struggling in a way that is going to work to the detriment of defendants throughout the state.
Well, T-Girl, you're wise, because I love your comment here. She must be a Stanford grad, and I know that that's made in jest. But I was thinking about that this morning, Norm, that this is perhaps a lens, an illustrative example of the type of things that we would see en masse in the next 6 to 7 to 8 years as matriculating law students are, given their licensure in various states and then begin to assume positions of public authority.
Are you tapping my phones, Mike? Because an hour ago I was talking to somebody about this and about not Derby, but I said I think it's going to take 20 or 30 years for the courts to collapse, because the courts are the one truly conservative institution in the United States. And what I mean to say by that is not that they have a political leaning to the right or left, but it's steeped in tradition and steeped in centuries-old doctrine and dogma. And so the cases that I'm litigating today might involve current controversies, but they use ancient legal doctrines, procedures, and norms to resolve them. Legal doctrines, procedures, and norms that were drilled into my head in law school, and that it has taken me decades to understand fully by going to court every day, where judges who were trained the same way superintend proceedings. Mike, you're on the beginning end of that, but you got the same kind of legal education. If people in law school right now are being taught to disregard the tradition, disregard the canon, look to diversity, equity and inclusion as a better way of achieving social justice than the rule against perpetuities, the statute of frauds, and the presumption of innocence. What are we going to get when these people become judges? We're going to get a free-for-all. And I think the battle for legal education that's going on in law schools right now I think it's going to take longer than 6 or 7 years, because what's going to happen is some wet behind the ear nerd from Stanford's going to walk into a courtroom and get bitch slapped right from one end of the room to the other and go call their malpractice carrier. And then they won't return for a while. But once these folks start becoming judges, as they ultimately will in 15, 20, 30 years, that's where I think the rubber meets the road, and where we're going to see real problems. But hey,
well, look, I guess a white pill moment here before we transition is that, and I don't use that, to be punny, although it does have a duplicative meaning here. But I don't think that the current environment is moving slowly enough to allow to afford the type of patience it would take for 15 or 20 years to materialize. So the nature of our society in 2023 is that information travels at warp speed. Viral moments happen in an instant, right?
Yeah, it does. But if you
so what I'm saying is that if this is a supernova, are we burning as bright and as hot as we might possibly get, or are we near that inflection point where we will start to see a decay in the energy around this stuff? Because from my perception, 15 or 20 years, the people who are active in this space right now, they've got to make their way in the world for another decade and a half, while everybody else is still getting their pants on and standing up to resist whatever decay and corrosion is going on with our justice system. So I think that ultimately there is, I think, optimism to be had and to be found, but it does require that all of us here, those of you who view this, who know law students or know young attorneys or know somebody who's of high school age and thinking about their career path, there's plenty of opportunity out there.
And Mike and I have talked about doing a special edition podcast for law students, and this reminds me that we need to resume that conversation, Mike, because if you're a young person in law school and your orientation to law school is from a DEI dean talking about your education is primary in creating a sense of diversity and inclusion, you should raise your hand and say, what did Oliver Wendell Holmes have to say about that? You should, where are we on federalism here? What does separation of powers mean? The basics matter, and law school is spending a lot less time on the basics and leading people to conclude that they can have some direct intuition into what justice is. And based on that intuition, they can redesign a society. I think that's a bass-ackwards way of looking at the world. The law is about conflict. The law is how we resolve conflict between people and societies. And it's a set of procedures, policies, and norms that are battled and time-tested, resolved to create a set of settled or set expectations among strangers so that we can live together in a community based on common norms. And so we need to have that discussion, Mike, and we need to provide a resource for law students so that they can continue to do the hard work of getting justice done in individual cases.
Well, yeah, and knowing that law school is already a rigorous enough process, and maybe it's changed, but look, I look at the Stanford law situation there with Judge Duncan being shouted down and the resulting embarrassment that is the administrator status of a DEI administrator, talking about, is the juice worth the squeeze, and getting all emotional about how uncomfortable it is for her to stand up there and arbitrate the dispute. The hopeful thing is, if Stanford's that way, disabuse yourself of the notion that you need a Stanford law education to practice and practice well, to earn your status as a practitioner, and to regard the law as something sacred to protect and use as a sword and shield in the respective situations. And I think that I'm a living, breathing example of that, Norm. I went through, I matriculated through law school, and I did not go to a pedigreed institution. Right. And so there is a pathway that's outlined, and we have plenty to provide on that. I think you and I could combine for a pretty productive product.
Well, we'll call it the Boyer Pattis School of Law.
We'll get some federally backed student loans and be on our way.
Well, there were other things we were going to talk about, but time just went through our fingers once again. So thank you,
just throw it on the
folks.
screen really quickly. Maybe we can get to it tomorrow. I know that
Yeah.
there's stuff in the news, Norm, that we talked about in text. There's stuff developing, so we can wait on that as well.
Yeah, I mean, just take a look at this story. Agatha Christie needs to be revised, her words redone, because, somebody reading a murder mystery might feel triggered by an anachronistic reference to a member of another group. I find this tremendously offensive and shocking, in the same way that I found removal of statutes from public places in the Summer of Love during those mostly peaceful protests in 2020 unnerving. We are our history. We are our past. And yes, we may need to come to terms with it, but we need to own it. What did Santayana once say? Those who forget history are condemned to repeat it. I think we're making a huge mistake trying to remake the world in a form that makes us comfortable. We need to come to terms with a world that is profoundly disquieting and discomfiting, and learn how best to adapt to it and how best to bend it to our purposes. Reworking Agatha Christie to satisfy the standards of some woke editor is an outrage. On the other hand, for those of us who own bookstores and are book collectors, it's great, because prohibited editions of Agatha Christie will fetch a premium for those who care about the truth.
Go to Norm's Book Barn, baby.
So listen, thanks for checking in with us, folks. Sorry we deserted you at the altar yesterday. Reality intervened, as it does from time to time. We think we'll be back tomorrow morning at 7:45. So thank you for listening to Law and Legitimacy. Mike, tell them how to help us.
Absolutely. Please go to Locals. We're on Locals, lawandlegitimacy.locals.com. You can become a member. You don't have to subscribe immediately, but your subscription will help do things such as the Pattis and Boyer law school idea, and plenty of other
Boyer and Pattis, come on, don't be so modest.
and then also to help us contribute to the content overall here. We do have plans. I want to get Norm to do some more exclusive stuff on the local side, and that's just going to take a couple of things. One, Gilligan's Island, aka the Hotel California, finally coming to an end and letting him check out of that hotel.
Please.
And then also he and I having a little more time to discuss on a pathway to deliver a better product to all of you. You can find us on Apple Podcasts, Spotify, Google Play, anywhere where podcasts are found. But most importantly, please give a thumbs up on whatever you're using, whether that's Twitter Live, which we're on right now, YouTube Live, which we're on right now, and the comments that display on the screen come from YouTube. So if it's important to you that you're saying something that you want us to put up for the viewers, please consider going to YouTube. However, Rumble is where our heart is. We're hoping that Rumble will actually integrate its software with StreamYard so that we can put your comments on the screen as well. And then finally, just to say it again, join us on Locals. That's going to be where Norm and Mike are able to generate the support and that we need to give you something a little bit better and continue elevating. So we appreciate all of you.
Objection.
Overruled, counselor. Wait.
Ready.
What rule?
It hurt my feelings.
I don't think that's the 304 acceptable definition, counselor.
All right. Thanks a lot. See you all tomorrow, folks.
See you later, Norm.